Good morning, everyone. First, I'd like to acknowledge that we are on the traditional territory of Kwantlen First Nation and Twine Quichin Council. I'm really excited today on behalf of the Yukon Law Society and the Continuing Professional Development Committee and the Independent Legal Advice Program at Yukon Government Victim Services to welcome you all here today. For those who don't know me, my name is Sue Bogle. I will be your moderator today. I am currently lead counsel with the Independent Legal Advice Program, and among other things, provide representation in 276 and 278 hearings here in the Yukon. So obviously this topic today is very near and dear to my heart, but clearly by the significant number of registrants today, there's widespread interest and relevance to many of us. I'm sure this sizable turnout of registrants has a great deal to do with our esteemed panelists. And I'm really excited to introduce all three of them. They bring far-reaching and diverse expertise in this complex and ever-evolving area of law. And I'm really excited, as I know all of you are, to hear them today. So to begin with, in no particular order, first is Dawn Wei. Dawn was called to the bar in 1997. She joined the Crown Attorney's Office in 2000 and then launched her own firm, Wei Law, in 2007. The majority of Wei Law clients are survivors of sexual assault, many of whom are children. Dawn's primary focus is advocating for and representing sexual assault survivors with trial preparation and privacy protection. And of course, that involving many 276 and 278 applications. She finds working with her clients intensely gratifying and fulfilling. Dawn also represents and advises organizations such as hospitals, counseling services, women's shelters, and corporations in criminal law matters, and also their obligations when subpoenaed. Dawn is the author of the chapter Representing the Victim in a Sexual Assault Proceeding in Prosecuting and Defending Sexual Assault Offenses, a Practitioner's Handbook by Danielle Brown and Jill Whitkin. I know I've certainly read that chapter many times myself. This leads me to our next guest, Jill Whitkin. Jill has worked as a Crown prosecutor in Toronto since 1994. She received her Master's of Law in 2002. Since 2016, she's worked as specialized Crown counsel at the Crown Law Office Criminal and is chair of the Sexual Violence Advisory Group for Ontario. Among many other leadership roles, she was co-chair of the Federal Provincial Territorial Working Group on Access to Justice for adult sexual assault victims and has been team leader of the child abuse team. She does trial and appellate work involving cases of sexual assault and child abuse, and is involved in training and legal education on sexual assault cases for lawyers, judges, police officers, investigators, and others. As already noted, Jill is co-author of the book, Prosecuting and Defending Sexual Offense Cases. And if you do any work in this area, I highly recommend this book, both for its legal analysis and very practical tips for practitioners. And then finally, our third panelist, Jake Legault. Jake has been working at the Bain, Seller, Attell Carter firm since 2013. He started there as a student and completed his articles in 2016. He practices both in French and English as a criminal defense lawyer. Jake has experience in various levels of court, defending clients in judge alone and jury trials. He has experience defending sexual assault allegations in Ontario, primarily in the Ottawa region, and experience in preparing and litigating Section 276 and 278.92 applications under the new legislation. Since 2018, Jacob has been a junior director of the Defense Counsel Association of Ottawa. So very excited. We are hopeful there will be time for questions. We're going to leave those to the end. I will monitor the chat box for those questions. I'm now very pleased to pass over the virtual floor to our first speaker, Jill Witkin.
Thank you so much, Sue, and thank you. I think what we're going to do is I'm going to start by just talking about this new piece of legislation. Well, it's not so new. It came about in December of 2018, and some of you in the audience may have those moments, you know, you remember where you were if you're a little bit older when JFK was assassinated, or maybe when Diana Spencer was killed. I remember exactly where I was when this piece of legislation was passed, because it was this momentous incident in criminal law. It's a big piece of legislation, and I think it's really had a big effect on the criminal justice system. I want to just start by talking about the three different provisions that it affects. The first is the production regime. In the criminal code, there is a production regime from 278.1 to 91, and this has been around for a few decades. And this relates to any private record that in relation to the complainant in a sexual assault case. And this regime kicks in when an accused person wants to get a record that is in the possession of a third party. So that's called the production regime. And as I say, that's been in place for quite a while. And this particular piece of legislation doesn't affect that, but it is related. The second piece of legislation is Section 276, and that's known as the other sexual history provisions. It used to be known as the rape shield laws that you may have heard of. And that regime kicks in when an accused person wants to adduce a piece of evidence relating to other sexual activity of the complainant. And again, that piece of legislation has been around for decades. It was declared constitutional by the Supreme Court back in the year 2000 in a case called Dara. So that piece of legislation is still in place, but there have been some changes to it as a result of Bill C-51. The most significant change to Bill C-51 in relation to this is a new section, 278.92, and this is relating to the admissibility where an accused person wants to adduce evidence relating to a private record of the complainant, which would be the same definition as the production regime, and we'll go through that. So I just wanted to frame it, first of all, by talking about these pieces of legislation that we're going to talk about. So the first change that was made was this other sexual history regime, Section 276. It is subject, if an accused person wants to adduce this evidence, they have to bring an application and they have to demonstrate a number of things, A, B, C, D. Originally, it was just B, C, and D, but now A adds that the legislation or the evidence can't be adduced for a prohibited purpose. And a prohibited purpose, which was included in the legislation before, is that it can't demonstrate, that evidence can't be admitted for the purpose of showing that the complainant is more likely to have consented on account of other sexual activity that he or she has been involved in, or that they are less worthy of belief. Those are the two qualifiers. So this really, in a sense, was a bit of a codification of existing law, but that is an additional provision. Also added under 276 sub 4 is a provision which specifies that any other sexual activity that is going to be the subject of this regime also includes any communication. I think traditionally, years ago, we were only dealing with acts, and an accused person would try to get in evidence in a trial of some act of the complainant, some other sexual act that he or she has been engaged in, either with the accused or someone else. And now Parliament has specified that not only is it the act, but it also may be a communication. So if the complainant is, for instance, communicating, texting, posting on social media, that would also be included under 276. And really there was case law that provided this, and Parliament, I think, just codified existing case law. This new provision that I talked about section 278.92. This relates to records, private records relating to the complainant, and we'll talk about what those are in a second, that are in the possession of an accused person. When I talked earlier about the production regime, that existed when an accused person would want to obtain a private record in relation to the complainant that was not in his possession, but that somebody else held. It may have been held by a Children's Aid Society. It may have been held by a doctor or a therapist. It may have been held even by the complainant herself. The accused wanted to obtain that record, and he would have to go through a two-stage process in court before a judge in order to get that. Now, this new provision applies even if the accused has that record, either by happenstance or because he's obtained it in some way, that he has to bring an application now in order to use that record in court. Parliament really wanted to close that gap between these protective provisions applying to the production regime, also now applying to the admissibility regime. So when we talk about what are these private records that apply now to both the production regime and to this admissibility regime, the definition of record is in section 278.1 of the Criminal Code, and it means any form of a record that contains personal information in relation to the complainant for which there is a reasonable expectation of privacy. And reasonable expectation of privacy, or the acronym REP, we're going to talk about later in a little bit more detail, and that's an important term. And in the Criminal Code, there is a non-exhaustive but enumerated list of the types of records that Parliament had in mind. And these include medical, psychiatric, therapeutic, counseling, education, employment, child welfare, adoption, social services records, personal journals, and diaries. Those are all the types of records that if there is personal information in those in relation to the complainant, those would be the type of records that an accused person would have to apply to obtain if they are in the possession of a third party, and now would have to apply to the court to use in court, whether that be by cross-examining the complainant or by just adducing the record itself. And the most common ones, I would say, are medical, psychiatric, and personal journals and diaries. We see those a lot. Certainly in the litigation in the past number of years, often accused persons would want to obtain therapy records, for instance, in relation to a complainant. And there's a whole procedure in terms of how they go about getting those therapy records, and they have to really demonstrate to the court that those are relevant and that they're not prejudicial. Similarly, if they wanted any sort of personal journal or diary. So there's an acceptance that each of these types of enumerated records would qualify as a record, a private record. But again, it's a non-exhaustive list, and it's not necessarily limited to these types of therapeutic or private relationships. So this new section 278.92 effectively says that if the accused is in possession of a private record relating to the complainant, he is not able to use it. It is inadmissible unless a judge determines, in accordance with procedures, and these new procedures are part of this new regime, that the evidence is either admissible under section 276. So if it's other sexual history evidence, that it's admissible, that it doesn't violate one of those prohibited myths, and that in any other case that it's relevant to an issue at trial, and that it has significant probative value, not substantially outweighed by prejudice. And the judge must in each case consider a number of prescribed factors. And the factors are listed here. You'll see there's a number of them. I'm not going to go through and read them, but this provides for a contextual analysis in each case, because the judge is going to have to consider each of those factors. And really what you can see is there's a balancing. On the one hand, the judge is going to have to consider the interests of justice and the right of the accused to full answer and defense. I'm sorry that there's acronyms used here, but FAD is full answer and defense. But at the same time, the judge is also going to have to consider, for instance, the potential prejudice to the complainant's personal dignity and right to privacy, and the need to remove any discriminatory belief or bias. And the whole idea of this regime is that the accused person, if he wants to use this evidence, he will have to articulate to the court what the purpose, what the relevance of that evidence is in this particular case, and why it doesn't engage any sort of discriminatory belief or bias or any prejudice. And so the judge will balance each of those things in determining whether or not the evidence is admitted. And it's, I think, important to mention, or important to say, that what the legislation does is it acts not as a bar, but as a filter. It doesn't mean that the evidence will not be admissible. It just means that the accused is going to have to go through a process, and a judge is going to have to make a determination that that evidence is admissible. And so there's a two-stage procedure that takes place, and this two-stage procedure now applies equally to 276 evidence, which is evidence of other sexual activity, and there's the provisions of changed numbers now, and also to this 278.92 evidence in the hands of the accused. So the procedures are really in two stages. The first stage is that the accused will have to make an application in writing, provide detailed particulars, articulate the relevance of that evidence that he wants to use, that he has in his possession, to an issue at trial. He will have to serve both the Crown and the clerk of the court, and that application has to be brought 7 days in advance, or that 7-day notice period can be abridged at the discretion of the judge if it's in the interests of justice. And at the end of the day, the evidence has to be capable of being admissible, and later we'll maybe talk about cases where it wouldn't be. And if those above conditions are met, then he's crossed the stage 1 threshold, and he moves into stage 2. So if a judge is satisfied that those things have been met, and really it's not a very strenuous threshold, as long as those things have been met, then the judge will order a hearing. Now, at the hearing stage, this is quite significant, because what happens at a hearing stage now is that the complainant may appear and make submissions and be represented by counsel, somebody like Don Way. And this is something that is completely new to both the pre-existing other sexual history regime. In the past, when an accused wanted to adduce evidence of a complainant's other sexual history, he would have to go through a 2-stage process, but it would only be the Crown and the defense and the judge who would be discussing the proposed evidence and whether it was relevant and whether the probative value outweighed the prejudicial effect. The complainant was excluded from that process, but Parliament now has given to the complainant very limited standing in this discrete hearing. So in the hearing where the judge would have to determine and balance what I talked about earlier, the right of the accused, for instance, to full answer and defense, balanced against the privacy rights of the complainant, and whether the evidence would engage any discriminatory belief or bias. So that is very significant, and that's the subject of much litigation, and certainly the subject of the constitutional challenge that is now before the Supreme Court. And so at that second stage hearing, the judge will determine whether all or part of the evidence is admissible. And certainly we do see cases that have been litigated where there may be, for instance, different pieces of other sexual activity or different records where the judge will decide some of them will be admissible and some of them won't. The judge has to provide reasons on the record. And in those reasons, the judge will have to refer to those factors that were listed earlier. And the judge has to state the manner in which the evidence is expected to be relevant to an issue at trial. And that decision of the judge, whether it's oral or written, is considered a question of law and technically could be appealed. So that's a brief overview of the legislation. And it is complicated. And it's something that Jake and Dawn and I have all been dealing with for quite some time, but certainly when it first came out, it was a little bit hard to wrap your mind around. So if you seem a little bit confused by it, don't worry, you're in good company. I'm going to now just pose a few, or Sue, I don't know if you want me to just ask the question. I'll just maybe go ahead and ask the question, or do you want to do it? Okay, so I'm going to just ask a few frequently asked questions, and these are ones that I would say are probably not particularly controversial, and they have been litigated to, I think, most people's satisfaction. The first is, are the Bill C-51 amendments retrospective? And really the answer is yes, they are procedural amendments. They don't, courts have found they don't affect the substantive rights of the accused, but just how the evidence is introduced. There are some cases that don't involve Bill C-51, which are on the screen, Dinley, Gibson, and SB, where that same analysis took place in the context of different procedural amendments. And specifically with respect to Bill C-51 jurisprudence, these are cases that have considered whether or not they are retrospective and decided that they are. So the quick answer to that is yes, and I don't think we need to spend much time discussing it because everyone's pretty satisfied that they are retrospective. When can an application be brought? So that third-party record production regime that I talked about earlier that's been in place for a few decades, the criminal code specifically says that that application has to be brought before the trial judge. So if you're at a preliminary hearing and you're an accused person and you want to obtain, let's say, a medical record or a therapeutic record that you don't have, and that's something for which the complainant has a reasonable expectation of privacy and would be included under 278.1 of the code, you can't do that at a preliminary hearing. You would have to wait until the trial in order to do that. And sometimes what happens at a preliminary hearing is an accused person might cross-examine a complainant in an effort to get a little bit of information that he can use as his evidentiary record for the trial, but it has to be brought in front of the trial judge. If an accused person wants to adduce evidence of a complainant's other sexual activity or has a record, a private record in his possession and wants to put that in either by cross-examining the complainant or otherwise, he can do that even at a preliminary hearing. He just has to bring the application. Bill C-75, which came out a few years ago, effectively changes the law somewhat so that for most sexual offenses, most 271 offenses where there's an adult complainant and the sentence is 10 years max, those cases would not have a preliminary hearing. So we don't see as many preliminary hearings anymore, but certainly ones involving a child complainant or the 272 or 273 more serious sexual assaults, those would have a preliminary hearing. So that's just an aside. And then a common question that arose after this legislation was passed was, is a record produced under the third-party record regime subject to 278.92? In other words, if an accused person before the trial judge brought an application, let's say, to get a therapy record or a medical record, and he obtained that record through that production regime with the judge. Now that he's at trial, does he have to bring another application, even though it may be more streamlined, to actually use it? And the courts, effectively, most of the courts, there's one that didn't, but most of them have said, yes, he does. That the two regimes are not a proxy for each other. And just because he has it, and he's seen it, and maybe the judge has seen it, that is fundamentally different than pulling it out in an open court and cross-examining the complainant on it, because that's different exposure and that's different experience for the complainant in terms of her privacy rights. And so he would still have to bring that application. From what I hear, my experience is that that will be a somewhat more streamlined application because a lot of the arguments about relevance and privacy may already have been litigated at that third-party record production application, but it would still technically have to take place.
Jill, can I just interrupt? Sorry, Jill, just to interrupt you briefly. I just wanted to let all our participants know that we will be sending them this PowerPoint presentation so that they will have these cases at their disposal and they don't have to write quickly while you're talking. So just wanted to say that. Thanks, Jill.
That's right. Yes, and I'm going to probably, after this slide, I'm going to stop sharing my screen and we're going to have a discussion about some other issues, but we have most of the cases that we're going to refer to, we do have on the slide and you'll be getting those later. So you'll have the citations for those cases. And what if the record doesn't relate to an enumerated offense? So these three pieces of legislation that I've been talking about all relate to sexual offenses. So, but an application has to be brought even if one of the offenses is a sexual offense and the other one isn't. Let's say you've got a sexual offense and a robbery, and there's a record, a private record in relation to the complainant, but the relevance is for the robbery charge, not the sexual assault charge, but they're all being litigated at the same time. The rule is you still have to bring the application, because at the end of the day, the complainant is testifying. Her credibility is going to be assessed holistically, whether she's testifying at that moment on the robbery or on the sexual assault, and her rights should not be undermined just because both charges are on the same information and the record technically only relates to one of the charges. So again, that's something that was litigated pretty early on, and as far as I know, there hasn't been too much controversy about that. So I'm going to now stop sharing my screen, and I'll hand it over to Sue.
Thanks so much, Jill. That's great. What's so wonderful about having all three of you is we've got the three main participants in these hearings, besides obviously the judge, in terms of having Crown, Complainants Counsel, and Defense. So I think there's obviously going to be some different perspectives on a lot of these issues, and it'll be really interesting to hear those different perspectives. So I'm going to start. I'm going to start asking Dawn. So we've heard from Jill the definition of record under 278.1, and of course that's been litigated in many cases, and will be decided hopefully soon at the Supreme Court of Canada level. But I ask you, Dawn, can a record include electronic communication?
Thanks so much, Sue, and thank you, Jill, for that excellent overview. I just want to start by echoing what Jill said. This is a pretty complicated area of the law. So if it feels like, gee whiz, it's hard to get on top of it, frankly, I think it is. So it's not just you, it's all of us. And on the question of the definition of a record generally, one case that you can look at is Quinnell, 2014 SCC 46 at paragraph 22. And the Supreme Court found that the definition of a record is broad and non-exhaustive, and that even where documents don't fall within those listed categories, they'll still meet the definition of a record, pardon me, if they contain information that gives rise to a reasonable expectation of privacy. Now, sorry, bear with me 1 second. My apologies. So in terms of, can an e-communication meet the definition of a record? The answer is yes. And in fact, if you look at the backgrounders to Bill C-51, some of them specifically refer to text messages, emails, and videos. So yes, they can. And then there's a series of cases that I'm sure we'll be working our way through as we give our talk this morning, which have carved out certain categories in which courts have found that a complainant would have a reasonable expectation of privacy in an electronic communication.
Thank you. Jake, can there be a reasonable expectation of privacy even in texts and emails between the accused and the complainant?
So thank you, by the way, for having me attend this. I'm happy to be here. And so to answer that question, I think like always, defense lawyers, it depends. In a situation of a record, text messages, emails between individuals certainly can have a reasonable expectation of privacy. And a lot of litigation has gone into whether or not certain messages do, and it's really on a case-by-case basis. In there's a decision of R versus MS 2019 ONCJ 670, which will be on the slides later, but Justice Chapman does provide a non-exhaustive list of things that the courts have to look at to determine whether or not there is a reasonable expectation of privacy in messages. The first thing to look at is really to determine if the record itself, so whether the messages that are between the parties include similar expectations of privacy that you would see in the enumerated list that is provided in the definition of a record, which is at 278.1. So if the content of the messages include things that are medical, psychiatric, therapeutic, things of that nature, that's really where the courts, it's sort of a starting point to determine whether or not it falls into the category of reasonable expectation of privacy or not. At paragraph 50, there's about 16 different listed enumerations of what should be looked at by the courts, or what can be looked at. It includes whether the information was gathered surreptitiously, or whether the information was given to the accused by the complainant. The medium is also a factor that is to be considered. And when I say medium, we have certain messages that you could argue should have a higher reasonable expectation of privacy. If it's, for example, a Snapchat that is a message that is sent and then is automatically deleted, that could be something that the courts would consider in assessing the reasonable expectation of privacy, as opposed to maybe something that is posted on Facebook or social media, where there'd be a lot more people who would have access to that record or the information contained in the record. So it really comes down as well to what the complainant's view was at the time that they sent the message. You know, does the message include something in it, or does the record include something in it that says, don't tell anybody else but? So for example, something like that would really lean towards a reasonable expectation of privacy if within the message itself, there's something suggesting that they did not want that information to be divulged. So the courts have found in certain circumstances that there is a reasonable expectation of privacy in text messages that can be between the accused and the complainant. They've also found in some circumstances that there are not, or that there is no reasonable expectation of privacy in certain messages. A lot of times when there is no reasonable expectation of privacy, it's maybe some innocuous text messages that really have no real personal information, or nothing that the court has found that would be sort of an invasion of the privacy. There's also been circumstances where there's been reasonable expectation of privacy found in voice recordings, and then certain circumstances where there is no reasonable expectation of privacy based on voicemails, for example, that are left on the accused's phone. I think I jumped ahead and answered the next question as well, Sue, but I hope that answers the question.
Can I just add something to that, Sue, please?
Yes, absolutely. No.
So we'll talk more about the reasonable expectation of privacy and how that's determined, et cetera. But I would suggest that the most effective way to deal with this whole issue is to ask the complainant if she's asserting a reasonable expectation of privacy over that communication. And in my experience with my clients, they tend to be very practical about these issues. And they have an understanding of the various platforms. For example, Jake was mentioning Snapchat. They know that stuff better than oldsters like I do. I've actually responded to 278.92 applications with basically a 2-sentence response that would say, my client does not assert a privacy, does not oppose admissibility of this evidence, and declines to participate at the hearing. So this doesn't have to be a complicated situation, particularly when the complainant is able to chime in on whether she asserts a reasonable expectation of privacy or not.
And I guess we will talk about waiver in the next few questions, but Jill, did you have anything to add on this as well?
Yeah, no, I think Jake did a good job of sort of outlining the fact that this really is a contextual analysis, and there's going to be a lot of different factors that the court is going to look at in each case. And certainly a few of the cases that we're going to have in the PowerPoint, one being MS that Jake mentioned, goes through those factors. When I sort of look at all the case law, at least one I can remember, I think that the more personal and intimate the exchange, the more likely that it is going to be found to be a record, and therefore it's going to have to be filtered through the legislation. You know, Jake mentioned innocuous exchanges. When you see exchanges between an accused and a complainant where they're talking about when they're going to meet or where they're going to meet or what time they're going to meet or who's going to be there, I mean, nobody really cares. And as Dawn says, the complainant's very likely not going to assert a privacy right over that. But certainly if there are intimate or personal exchanges with the accused person, and the important thing I think is at the time that that exchange was made, I think those are the ones where a complainant would reasonably say, no, I sent that text message or WhatsApp message or whatever it was with the expectation that it was only going to the accused. And we know from the Supreme Court in Morocco that text messages can have a reason and should have a reasonable expectation of privacy. And when we think about our society now, I mean, even the older generation, and I include me in that, I mean, everybody is communicating by text, right? Or by some sort of digital platform. People engage in text messaging more than they engaged in phone calls, it seems. And so a lot of private things are shared that way. And it will be a contextual approach, but I think we certainly are at the point where anything that is sort of intimate or personal that is exchanged is likely going to be captured. And while there is some conflicting case law, and we'll see if the Supreme Court opines on this, I don't know if they will, but one judge, for instance, in going through the policy implications of this legislation in a case called WM in Ontario said, well, if the complainant and the accused engage in communication and she later goes to the police and complains about him, how can she have a reasonable expectation of privacy over that communication such that he's not going to be able to use it in defending himself? And so she found that there was no reasonable expectation of privacy partially on account of the fact that the complainant subsequently went to the police. Another judge in Ontario in a case called TA, which is included in the materials, said, no, that's not right, because you can't, then you'd have to censor every single communication for fear that afterwards, if you're sexually assaulted and you go to the police and complain, that somehow you don't have privacy protection, and that wouldn't make sense. So I think there's a bit of a division in the law on that sort of analysis, but I do think that in most cases, what we've seen is things like exchanges between a complainant and accused about her addiction or her father's mental health problems, or her amorous feelings and intimate feelings towards the accused, not sexual, but just amorous feelings towards the accused. Those have been found to be protected under the section. Those are the types of communications, whereas other ones that are more innocuous are not. So I think in every case, it is going to be a case-by-case analysis, but I'd like to think that with the body of case law that we have now, and certainly when we went to the Supreme Court, we tried to kind of summarize that case law to give them a sense of what types of communications were being found to be included and which weren't. To demonstrate it's not every communication. I think the fear at the beginning for everybody was, oh my God, every single communication between the accused and the complainant is now going to have to go through this process and slow down trials. It doesn't have to be that way. And as Dawn says, good counsel is going to look at the communication, knowing the state of the law, receiving proper informed instructions from the client, and not necessarily seek to litigate.
I know I'm sure a lot of the participants are anxious to hear about some of the issues that were addressed at the Supreme Court of Canada, and we're lucky that two of you were actual participants in that hearing. I can tell everybody we have set aside time at the end to discuss that litigation, and we will do so. It will be interesting to get that decision. There was some joking that if it had come down yesterday, this could have been a much different presentation. We'd all be scrambling to try and read the decision, but that didn't happen. So here we are. Okay, well, moving on to the next. I think, yes, there was a question about photos and videos. I'll ask you this, Dawn. Can there be a reasonable expectation of privacy in photos and videos of the alleged offense?
Well, it would seem to me that if it's, if the actual offense has been captured in a photo or a video, that is obviously going to be admissible. It'll be highly probative to the triable issues. If you have an hour-long video and 30 seconds of it captures the offense, then it would seem to me that the complainant would be able to assert a reasonable expectation of privacy over the broader video. And frankly, I'm not sure why a complainant would want to assert an expectation of privacy if the video or the picture actually captures the event. So I'm not sure if that's a clear answer to the question, but I think, yes, it's possible that would happen, that a reasonable expectation of privacy could be found. However, it would seem to me that it would more apply to extraneous information that was captured in that recording, as opposed to the actual events that led to the charges.
And maybe just taking one step further on that, what if there were electronic communication, texts and messages that discussed the actual offense itself?
Well, that's interesting you say that, because when you're talking about when Jill and I were at the Supreme Court, it seemed to me that was something that the judges were very interested in. And they seem to want to find a way to articulate a bright line test that, and Jill, I'll certainly hope that you'll correct me if you think I'm wrong on this, that would articulate no reasonable expectation of privacy in communications between the complainant and the defendant regarding the actual allegations. Now, of course, this gets a little bit complicated because, it would have to be clear that that's what they were talking about, and that, we may have some gray in these issues. But I think that courts would find that there was no reasonable expectation of privacy if it's a communication specific to discussing the allegations.
And I agree with Dawn. And yes, that was definitely an area that the court was interested in. And I guess, if you step back and you think about it, if a complainant goes to the police and gives a police statement, which is going to then obviously be part of the litigation, it's going to be in the public forum if she's given a police statement, and she's talking about the offense in question, it's hard to argue that if she communicated with the accused about the offense in question, that she could retain a reasonable expectation of privacy. Because in other words, if she's talking to the police about the offense, and then she's also talking to the accused, one would think he should be able to legitimately cross-examine her without having to bring an application beforehand. Whereas if she's talking with the accused prior to the offense taking place about something else personal, or about some other sexual activity, one can understand why she couldn't reasonably expect that she would be asked questions in open court with no notice about those things. But it seems reasonable that she would expect to be asked about things that she may have said that are inconsistent to the accused with what she said to the police. So we don't know what the Supreme Court's going to do, but I think I would be surprised if they would hold that communications about the offense were covered under records. Now, we were talking earlier about photos of the offense itself and videos of the offense itself. And I agree with Dawn that you can't imagine a situation where those would not be admitted. And I guess maybe it depends on where those come from. If those are for some reason part of the Crown disclosure and they make it to the defense, then obviously the complainant's going to know that those are going to come into evidence, and the Crown would prepare them for that. But if the defense, let's say, has a video or a photo that the complainant isn't aware about, and it is about the offense in question, I agree that it doesn't fall under Section 276, because the other sexual activity regime that applies to other sexual activity doesn't apply to sexual activity of the offense in question. But there is an argument maybe that as a record, because a photo or a video would still be a record, it's a sexual record, and would she reasonably have an expectation of privacy over that sexual record being put to her with no notice? And I think that's the key here. Again, this is a filter, it's not a bar. It doesn't mean that that record won't ultimately go into evidence, but for her to be, and I'm going to use the word sort of ambushed without notice, with a naked picture of herself, certainly I would argue that does fall under the definition of a record, not under other sexual activity, but under the definition of record, something for which she has a reasonable expectation of privacy that should be filtered through the provisions. And it may be at the end of the day that it's fair game that she's cross-examined on it, but at least she is aware of it beforehand and can emotionally prepare herself. I don't know, Dawn, if you disagree with me or not, but those are just my thoughts on that.
No, I completely agree.
I guess because there isn't really yet a bright line test on, and these are difficult areas. I ask you, Dawn, and I would imagine this would lead into a discussion about waiver by complainants of some of this material. But what if a Crown gets this kind of evidence on their file and they maybe mistakenly disclose a record in which the complainant has a reasonable expectation of privacy? What actions can be taken if that happens?
So this is something that happens periodically. And the complainant goes to the police, and perhaps she provides them with something, her diary, text messages, medical reports, whatever. I've seen cases where somebody else provides the police with the information. It doesn't really matter who provides it to the police. Once the Crown is in possession of that record, it's not to be disclosed to the defense if the complainant has a reasonable expectation of privacy. However, pursuant to Section 278.2 sub 3, the Crown would advise the defense that they have a record in which the complainant has a reasonable expectation of privacy, but they're not to disclose what the contents are. And then the defense lawyer can decide whether or not he wants to bring an application for production of that record. So what happens in the case when the Crown gets that piece of that record and they disclose it to the defense without a valid waiver? And this is key. The complainant has to provide a valid waiver expressly foregoing her privacy interests in those records. And we have a case from Ontario, the case of Plant, P-L-A-U-N-T, 2006 OJ number 2175. And paragraphs 21 and 22 discuss what constitutes a valid waiver. So the person to whom the record relates, it has to be shown that that person understood the protections that were afforded them by the legislation. And here we're talking about the old, still current third-party records regime, starting at paragraph section 278.1. And it has to be shown that the complainant expressly waived those protections with a full understanding of the consequences of that waiver, including the potential that the records would be disclosed to the accused person. So what all that means is very often this evidence has fallen into the hands of the Crown without a valid waiver. And there are 3 relatively recent cases in Ontario that considered this. One is R.V. Gray, 2015. The other is J.M., 2020. And the last is Belondo, 2021. Gray had to do with counseling records, JM was CAS records, and Belondo was medical records. So the court in each of these cases ordered the defense to return the records to the Crown. There was some criticism of the Crown having allowed this to be disclosed inadvertently. And the courts found that the applicant then had to bring a third-party records application. So we do have a way to remedy this situation. It often doesn't unfold that way, but there is that possibility. Now, I'd like to now try to be technically savvy and share my screen. So just bear with me for a moment. Okay, so hopefully everybody can see this. Oh, that's not what I wanted to share. I'm sorry. Pardon me. Okay, I don't know why that's happening. I'm clicking on the correct file, but the wrong file is popping up. Okay, so I'll just explain what I wanted to show you. There was a case I was recently involved in. The complainant had been alleged that she'd been sexually assaulted by her boss at work. She had text messages in which she says to the boss, words to the effect of, "You shouldn't have touched me at work. I'm not coming back." He says, "Please call me." She says, "No, I won't." He says, "I'm sorry about what happened." She says, "I'm so upset because I was previously sexually assaulted as a child." He says, "I'm sorry, please come back to work." So that text message was disclosed, was provided to the police by the complainant when she made her initial complaint, and they had just exchanged that text message within the last 24 hours. It was then disclosed to the defense. About 2 years later, a senior Crown gets on the file, sees that this has been disclosed, and says, "Oops, the complainant has a reasonable expectation of privacy," specifically because of the comment about her being a survivor of childhood sex assault. So how we dealt with that was the Crown contacted me. I provided ILE to the complainant. She ended up asserting her privacy interests over that one sentence that referred to the childhood sex assault. The Crown then contacted the defense and said, "I'm opposing the admissibility of that one sentence. If you want to adduce that at trial, you have to bring a 278.92 application." So there's a real life example of how that kind of situation can be dealt with.
Dawn, it's my understanding that in terms of waiver, a complainant can't waive evidence of prior sexual activity. Is that correct? They can waive other things, but when it comes to the judge is the ultimate gatekeeper in relation to.
Oh yes, that's absolutely right. And the trilogy of cases coming out of the Supreme Court a couple of years ago, Barton, RV, and Goldfinch all underscore that it is the trial judge who's the gatekeeper. So going back to an earlier comment that I made about the complainant can say to the court that she does not oppose admissibility, but it's not her decision. The judge still has to make a determination on the basis of all the factors about whether or not that evidence should be admissible.
And I'll just throw a wrench into things. We had some debate in Ontario amongst Crowns about whether or not we would disclose, let's assume that the complainant disclosed to the Crown an arguably private exchange between her and the accused. Somewhat similar to what Dawn was talking about. Maybe it had sexual information, but it was a private exchange. The question was, would we go ahead and disclose that, even though technically there is a reasonable expectation of privacy? And some Crowns certainly thought that it wouldn't be inappropriate to disclose it because it's something the accused has already seen. So we can't disclose anything that we get that is in the possession of a third party, a therapy record, a medical record, something like that, which the accused has never seen. We don't disclose that. We absolutely can't disclose that. but arguably there may be a distinction to be made between something that the accused has already seen that we're content to disclose to keep the process moving so that we don't hold it up. Maybe we can't find the complainant to get a waiver, and we want to move everything along at the pretrial stage, but we would disclose it saying, we say that she does have a reasonable expectation of privacy over that portion, and the accused would have to bring an application if he wanted to use it. But because it's something he has already seen, because it's an exchange between them, we would draw that distinction between disclosing it and adducing it.
I see a question, and it leads very well into our next topic, which is going to be a motion for directions. And I'm just going to read it out. As text messages can sometimes fall under 278.92 and sometimes not, should a defense lawyer always make an application in advance for the evidence to be admissible? So leading up to that, Jill, I'd ask you to talk about a motion for directions.
Okay. Well, I can tell you that if I would have answered this question a year ago, I probably would have answered it differently than I would today. A year ago, I would have said it's proper for a defense to bring a motion for directions, and what it really is. And I will say, you know, with all due respect to the defense bar, this is something that was created by the defense bar. There's nothing in the legislation that talks about a motion for directions. It talks about the stage 1 and stage 2 part of the application and hearing, which I went through earlier, 278.93 and 94. There's nothing in the legislation that talks about a motion for directions. But what was happening is, because there was so much controversy over whether particularly communications between an accused and a complainant are those records, right? And we've talked about the fact that courts now have decided they are in some cases and some not. But at the very beginning, defense counsel didn't want to show their cards, because remember, once the hearing is ordered, at a minimum, the complainant is part of it. And she's going to be able to see what that record is, because if she's part of the hearing, and we'll talk about that after, but she's in most cases going to get disclosure of the application record, which is going to refer to that record. And so the defense didn't want to show their cards unnecessarily. So they were bringing, and they still continue to bring, what's called a motion for directions. And basically it's like a pre-trial motion before the judge, where the defense would say, Judge, these are the records that I want to adduce at trial, and I want a ruling from Your Honor that these do not qualify as records as defined by 278.1. And it was complicated because in Ontario anyway, the defense didn't want to even show those records to the Crown. They wanted to show them only to the judge in a sealed envelope. We called it a reverse Garofoli. And there would be this coded communication between the judge and the defense about each of those exchanges. And the Crown, we litigated, we tried to get rulings that we should see the records so that we can make meaningful submissions, but we didn't have much success in that, at least not in Ontario. And so along went all of these motion for directions, where for the most part, it was the judge looking at the record, and with submissions from the defense and submissions from the Crown, at least about the state of the law, was making a determination about whether that record, that particular record, was private or not. And if it was private, it went in the pile of, you have to bring an application before you use it. And if it wasn't, then they could go ahead and they could use that record. So that's what a motion for directions is. There have been many, many cases that have entertained these motions for directions. I think what I would say now, having thought about it over time, is that, and I say this because I know the frustration of so many pretrial motions having to be scheduled, because you'd need to schedule your motion for directions. Then once that is over, you have to then schedule your stage 1 hearing, then your stage 2 hearing, and then you get to the trial, and it's really bifurcating and delaying trials. I think the motion for directions could just as easily be litigated as part of the stage 1 application. The stage 1 application, according to the legislation, the complainant does not have standing at that stage. The complainant has standing at stage 2. There have been some cases where the complainant has been granted standing at stage 1, but I think that really you could streamline those arguments all into the stage 1. But irrespective of whether it's 3 different pretrial motions or 2, the motion for directions really is an application by the defense to have the judge declare whether a particular record in question qualifies as a record, whether it has that reasonable expectation of privacy. And I know that, and I'm sure Dawn will weigh into, well, how can the judge determine that without the complainant being a part of that conversation? And I'm sympathetic to that argument as well. But that's what a motion for directions is.
Yes, Dawn, I know you argued this at the Supreme Court of Canada recently.
That's
so-
right. And where I differ from Jill on this is I think that the key question is whether the complainant has a reasonable expectation of privacy. And in my view, that should be litigated at the stage 2 hearing. There are numerous problems with the motion for directions from the perspective of the complainant. Not the least of which is it sits completely outside of the legislative scheme. And it adds another layer of litigation to what are already very busy courts. I don't think it's appropriate to have it at the stage 1 hearing. And here we can look back to third-party records applications. And it's not uncommon for the defense to say on a third-party records application, well, she doesn't have a reasonable expectation of privacy in this record for whatever reason. That doesn't mean that the complainant is excluded from that decision. The complainant is still an active participant in every aspect of the hearing, and she chimes in on whether or not she has a reasonable expectation of privacy. So drawing on our over 20 years of experience in third-party records applications, I think we can apply that to a 278.92 hearing and rightly place that question at stage 2 where she has standing. As I said earlier, the most efficient way for us to deal with this issue is to ask the complainant if she asserts a reasonable expectation of privacy. And that can deal with things very efficiently. And as an aside, just as a global comment on this issue and other issues, well-placed ILA for the complainant can save hours, if not days, of litigation down the road. So there can be real benefits to the complainant having ILA early in the process. The entire reason for this legislation is to protect the privacy, dignity, and equality rights of the complainant. And yet, if this is argued at either a motion for directions or at stage 1, then the complainant has no say in it. And that must, in my view, undermine the intention of Parliament. Also, the Supreme Court in ALL v. BA, which is a 1995 decision, they held that the courts must provide the opportunity to be heard to those who will be affected by the decision. The complainant is affected by this decision, and yet she's excluded if it's at a motion for directions or at stage 1. A nice little case that came out of Ontario is EA. Citation is 2020 ONSC 6659. That case held that the complainant should have standing on a motion for directions. And if we apply Jill's analysis and we have the reasonable expectation of privacy argued at stage 1, then she would also therefore be entitled to standing at stage 1. But I don't really think that that's what Parliament intended. Stage 1 is supposed to be a low threshold. The question is it, besides the technical requirements, is it capable of being admitted? So for example, if it's twin myth based, it's not capable of being admitted. All the other substantive issues we should be dealing with at stage 2. Also, participation of the complainant on the question of reasonable expectation of privacy will help weed out misleading evidence that can come from this type of evidence. For example, without the participation of the complainant, there is no way for the court to know if the records are authentic, if she actually drafted them. And I've certainly been involved in cases, not a case that's actually percolated up to being reported, but cases where she denied that she had written the record and he had access to whatever the platform was that was being used. And I'm going to try again to share my screen because I do have something I wanted to show you. So we'll see if I have any better luck this time. Okay, I do not know why it's doing that. So another case, another text message, and I wanted to put it up to be able to show you, but for some reason I can't do that. The defense brought an application under 278.92 where there was an exchange between a mom and a child. Child had alleged having been raped by her father as quite a young child, pre-puberty. She's removed from the home, put into a foster home. About 2 years later, there's an exchange between her and her mom. And the mom says to her, so you want to see daddy? The little girl says, yes, I do. She says, I'm not going to tell anybody, but it never happened, did it? Talking about the allegations. And the little girl replied, he hit me, that's all that happened. So that's the text message, the series of text messages that the defense wants to adduce. And the defense says, this is evidence of a recantation. And when I reviewed the application, which was a well-drafted application, it looked to me like this would be a situation where I would concede the admissibility of that text message. However, as it turned out, the very next text message, which was not included in the defense materials, the mom said, okay, but nothing sexual. And the little girl replied, no, it hurt me when he took my virginity. So that would never see the light of day, but for the complainant being actively involved in the process of determining her reasonable expectation of privacy. Further, there's an argument to be made that the motion for directions is a backdoor attempt to circumvent DARA, which found that the defense did not have the right to ambush the complainant and take her by surprise. So I think that that'll do for now. Sue, I've taken up enough of everyone's time. Needless to say, in my view, the complainant has to be an active participant in the question of the reasonable expectation of privacy, and that should happen at stage 2.
Jake, your turn. How Jill spoke to it a bit, but how does the motion for directions benefit the accused and their counsel?
Yeah, so I mean, I think Jill covered most of it, but really, I think, you know, and I appreciate, you know, when these were just starting, I think defense counsel sort of took a step back and said, well, wait, hold on. I think we need to actually determine whether this is a record or not before we decide whether to proceed, right? Because that's really a record with a reasonable expectation of privacy, sorry. So that really, I think what prompted defense lawyers to start saying, well, you know, we could avoid this whole thing, these 2 stages, if this is a record that in which a complainant would not have a reasonable expectation of privacy. And I appreciate everything that Don and Jill have both said, but in the same sense, you know, if defense counsel, you know, in defending sexual assault cases now, there's definitely more hurdles now due to this legislation. And I think the defense counsel have been, you know, pushing back when they can. And I think the motions for direction, again, when we come back to these decisions that have been made on these motions for directions, whether it's innocuous text messages that really don't have anything about a reasonable expectation of privacy, then why shouldn't the defense lawyers be bringing these motions for directions? Certainly in, you know, the case law is varied, but if there's a possibility of not having to, I guess, show your hand and show the exact messages that are subject to the, you know, the subject to the to what would be the application. Now, you know, it all depends on what's in the messages. I mean, there could be, you know, I've looked at text messages and said, well, for sure, there's gonna at least be some reasonable expectation of privacy, and then you decide not to bring one and you go straight to stage 1. I think it's really a tactical decision that's made by the defense counsel, but for now, it's one that's available. It's one that the courts are following up on. And if there's a way at this point to not have to necessarily disclose the content, then it's something that defense counsel should continue to use unless they're, told otherwise by a decision by the Supreme Court, I guess.
Sue, I just wanted to add that, when the legislation was first passed and everybody was a bit confused for how they're supposed to deal with it. And I have to say, at the beginning, it wasn't clear that text messages between the accused and the complainant were the subject of a record. It's not enumerated in the legislation. The legislation is obviously a non-exhaustive list. And so I think that needed to be litigated. But then in addition to that, the types of conversations, the types of communications that would fall under the definition had to be litigated. And that's what happened in these motions for directions. I think now, a few years later, we have a pretty robust body of case law where we can sort of synthesize the types of records that would be included and not. And absolutely, there is going to be a gray area, but there's also going to be a pretty black and white area, right? If you're talking about innocuous stuff, like everyone's going to agree that doesn't need to go through the system. If you're talking about personal, obviously, if you're talking about sexual, that does have to go through. And I would hope, and maybe the Supreme Court will give us some guidance on this, so that we don't even need these motion for directions for a lot of cases, because it will be clear to all of the litigants and to the judge, including complainants counsel, what types of records would be included and what wouldn't. And where there is that gray area, then maybe you do need some sort of a, whatever you want to call it, a motion for directions, a stage one, and the complainant perhaps has the ability to make submissions on that. I hear what Don's saying about the authenticity, and that is certainly an issue. You don't want to have to deal with that in the middle of trial. You want to have to deal with that before. I suppose if the record is going to get to a stage two, it's something that could be litigated at the stage two hearing. But authenticity is certainly an issue.
And if I can add as well, there's also the when you're defending these types of cases, from the defense perspective, bringing a motions for direction for something that the defense is quite confident is gonna, there will, I'm talking about the innocuous text messages where they're quite confident that there's gonna be no reasonable expectation of privacy. It's kind of nice to go through a motions for directions for those, as opposed to showing up and starting to cross-examine the complainant and then bringing these text messages. And, you can appreciate that in trial practice, the Crown could get up and say, well, wait, what are these? Where are these coming from? Nothing's been litigated yet. So it does provide some certainty, which is something that's nice, because I can envision, when it's more black and white, I can appreciate that there might be this ability to sort of try to decide on your own as a defense lawyer whether it falls or it doesn't. But then if you spring this on in cross-examination, and then I think ultimately it will still somewhat halt the proceedings for a little bit until we get to the bottom of it. And I guess that's the only issue I envision, even if, the defense lawyer takes the position that there's no reasonable expectation of privacy. It can still have the sort of an adverse effect at the trial itself, in practically speaking.
I think that the thing that we can all agree on is that we hope that the Supreme Court gives us some really clear guidelines. So.
We hope, we really do. Without, 5 concurrent decisions that all go the same way, right?
Yes.
And I think, Sue, I think we've also at the same time answered the next question about should the Crown see the record? Because this is not codified, judges have taken divergent views. The case I've already talked about, the BC Supreme Court, it was R versus RW 2021 at paragraph 17. It sort of goes through different cases and what different procedures have been applied. Sometimes the messages are given to the Crown Counsel, even at the motions for directions. Sometimes they're not. ultimately it comes down to your trial judge in determining what route to take on the motions for direction. It really, unfortunately, right now it depends. It depends on what positions both parties take, and then it depends on ultimately the position of the judge as well in terms of how to run the motion.
I can tell you, Sue, that in Ontario, we were certainly arguing at the beginning, and I do take the view that the Crown really should see the messages, even if we're at a motion for directions, whatever you want to call it, because the Crown is an officer of the court and is there to assist the judge. And we can't meaningfully assist the judge if we don't know what the record is that we're talking about. We may be aware of case law that would be directly relevant to that type of record and whether or not it would qualify. And I appreciate leaving aside the issue of whether there is this subjective or even objective reasonable expectation of privacy that someone like Dawn would come in and speak about. But if you just looked even at the content of the record, whether or not it would be included. But in Ontario, I would say most judges have acceded to the defense in terms of not providing that message to the Crown at the motion for direction stage. We do have a decision by Justice Christie called AM. It's in the materials where she suggests that there should be effectively a judicial summary that is provided to the Crown. And that would include things like the date range of the record, what medium it's on, whether it includes anything sexual, who are the parties privy to the communication, how did the accused have possession to it, things like that. I don't know how that helps the Crown really, because if we don't know exactly what the message is, we can't really do much with it. But that's her suggestion, that there is a summary that's given to the Crown by the defense, and the judge can actually supplement it if they feel there's more information that the Crown needs. And I guess the only other thing I would say is that unlike Dawn, who represents the complainant, who has obviously a confidential relationship with the complainant, if the Crown is privy to information, we're in an awkward position if we know about it, but then we have to almost disabuse our mind of it if the ultimate determination is that it is not made out to be a record, because then when we go to preparing our complainant, we almost have to forget about it because the complainant shouldn't be privy to the record that is going to be put to them in cross-examination. So I think there's arguments on both sides, but for now, at least in Ontario, I don't think Crowns are, for the most part, getting a copy of the record at that early stage, unless the complainant is given standing at that stage.
Very interesting area, like you say. We hope we get some guidance from the Supreme Court again on this. I can say, just from Yukon experience, I've only been involved in one, and the defense counsel had no difficulty with me being present for the motion for directions. So, and that was actually a Vancouver counsel. So.
Was it you being present or you actually seeing the records in question?
Yeah, it was actually more I was able to see the records in this particular case.
Right.
Yeah. So, okay. I guess now we move on talking about application materials. Dawn, moving from the motion for directions, but going into the stages, is the complainant entitled? We've heard that, and obviously it statutorily says that there's no standing for the complainant at stage one, but do you feel that the complainant's entitled to the application materials at stage one?
No, I don't. Early on, when this legislation was first passed, we had a lot of applications where both stage one and stage two were scheduled together. And it was not uncommon for me to get the application materials before stage one. And I'd often even sit in on stage one because, so hard to get court time. And the plan was we'll do stage one and then we go right to stage two. But the complainant is not entitled to the materials at stage one. And in fact, for practical purposes, I don't really want the materials at stage one. I only want to know what I'm going to have to litigate at stage two. So if the defense brings a stage one application and they're asking to adduce on 5 areas, say, and only 3 of them end up going to stage two, then I only want to know about those 3. In terms of scheduling, I think it's really helpful to have the stage 1 hearing or appearance, not really hearing, well in advance of stage 2, because we may end up with a judge who needs to consider what their decision is going to be on stage 1. Also, we'll hear about this in a little while. The technical requirements are somewhat different between stage 1 and stage 2. So the defense may well need time to put together a personal affidavit from their client, for example, in order to provide that on the stage 2 materials. So I would recommend that where possible, stage 1 and stage 2 are scheduled with a good cushion of time between the two.
Any other comments on that? I know procedure differs from jurisdiction to jurisdiction. I know often in Yukon, we do stage 1 and stage 2 at the same time. I don't make submissions as complainants counsel generally on stage 1, although I have been able to from time to time with leave of the court, but often we go right into stage 2, or there's argument by the Crown that we shouldn't even move to stage 2, but I'm usually present for that.
I think this is also I'm sure Jill can attest to this as well. This is when it's good to have a good dialogue and communication with the Crown who's dealing with the case in a situation where there's a stage 1 and a stage 2, because and I appreciate that at stage 1, the judge still obviously ultimately makes the decision. But if this is a case where, and I've had cases like this where it's clear that you're going to reach the low threshold that you need to on stage 1, and the Crown is going to also, the Crown can't make the decision, but the Crown is going to be of the same view. I've certainly had cases where we present stage 1, it takes about 10-15 minutes or so in order to get through that stage 1. And I think Dawn also sort of touched on that as well. If it's sort of, the writing, I don't like to, if the writing's on the wall and you're going to get through that stage 1, then you provide the affidavit from the client, from the accused, to the complainant's counsel. And it's just everyone, sort of knows that we should be getting through stage 1 rather quickly. And then we can really move into stage 2, which is really what's going to be at the heart of the issue. That I think sometimes, and it also helps, I think judges do appreciate that sometimes, because it also does avoid you needing 2 separate days of litigation.
I completely agree. And often the Crown concedes stage 1.
Right.
And that really is then just a 5-minute appearance in court, and then we bump over to the stage 2 hearing. So for sure there can be efficiencies. We shouldn't leave the audience with the suggestion that the Crown is always going to be opposing stage 1. In fact, very often the Crown will concede the stage 1 threshold has been met.
Absolutely. Yeah, I agree completely. And we are encouraging Crowns in Ontario that if the low threshold is met, there's no reason that they can't concede it. And again, as Jake said, ultimately it's the decision of the judge, and it's a decision that has to be made on the record, but it could be a 5-minute appearance. And those are the kinds of things that I think could even be discussed at an earlier judicial pretrial. So when you're discussing how many hearings you're going to need, if there's no need for a motion for directions, if the Crown says, if we know it's, let's say it's 276 type evidence, we know it's capable of being admissible, all the prerequisites have been met in terms of it being in writing and the relevance being articulated. It's almost something that could be done in writing with maybe just an endorsement on the record, and that could save a lot of time for sure, and leave the court for the stage 1 applications that do need to be litigated. There will be some where the Crown disagrees that the evidence is capable of being admissible. And I would put maybe a distinction. Remember, we're talking here about either private records, right, that are in writing, or we're talking about other sexual history evidence, either communications or actual evidence. And what the code says is that you pass stage 1 if the evidence is, in the case of 276, capable of being admissible. So all you're looking at there is, does it violate one of the twin myths? And if it doesn't violate the twin myths and it's in a specific instance of sexual activity, then it is going to be capable of being admissible, or at least get to stage 2. If it is a record, so any other evidence, it just then has to be relevant to an issue at trial or the probative value outweighing the prejudicial effect. And again, I think at that stage, the stage 1 requirements are going to be a very low threshold. As long as it's in writing, it's served 7 days in advance on the Crown and the court, and relevance is articulated, I think that the real meat of the argument is going to be stage 2. So I think in a lot of cases, the Crown may very well be conceding stage 1. Again, unless there's an issue with it not falling properly under the type of 276 evidence that would be admitted, or potentially it being an issue of whether or not it's actually a record. And I would hope that as time goes on, these things can be streamlined and that stage 1 applications don't need to take very long at all. And they could be scheduled for a speak to as opposed to a half-day hearing, because that will move things along much quicker.
And I guess then Dawn, moving on to stage 2, is the complainant entitled to the application of materials at stage 2?
Yes, she is. There is some cases out there that hold that she's entitled to the full application. There was some pushback from the defense saying that the complainant shouldn't receive the full application, but we've got the Boyle decision, FA, and Morello, and the site, I don't think that's in the materials. The citation is 2020 OJ number 3617. And just from general practice, the way that this is all evolved, I get the full application after it passes stage 1. On occasion, someone will send it to me before it passes stage 1, in which case I email back and I say, I don't think I'm entitled to these until stage 2, so I won't be reviewing these materials. So, but yes, the complainant is entitled to the full record at stage 2.
I want to ask Dawn a question. Have you ever had a situation where either the Crown or the defense has sought to redact any part of the original application? For instance, if it has materials that maybe the complainant doesn't need to see for the purpose of the application, maybe it refers to other evidence in the file that wouldn't be needed and might otherwise taint the complainant inappropriately? In the new legislation, I don't believe that I've dealt with that situation. I have had that pop up years ago in the context of a third-party records application. In that particular case, the defense said that the complainant shouldn't get the full application record. Very senior judge at Toronto SCJ basically said, if you're choosing to bring this application, the complainant is entitled to the full application. So I would certainly resist the suggestion that the complainant was not entitled to the full application. Complainant's counsel needs that to be able to assess the admissibility of the evidence, take a position on that. So yeah, my position on that would be that the complainant should always receive the full application record.
All right, well, we're talking about stage 2, and it's been obviously discussed that the complainant, and it's in section 278.94, Jill mentioned it, sub 2, that on a hearing, stage 2, that the complainant is not a compellable witness at the hearing, but may appear and make submissions. And the question here is, when and how should the complainant be advised of the right to counsel? And in the code, subsection 3 says the judge shall, as soon as is feasible, inform the complainant who participates in the hearing of their right to be represented by counsel. So that's what the code says. I'm sure it varies from jurisdiction to jurisdiction, and obviously you'll let us know what happens in Ontario. I can say that the benefits of a small jurisdiction such as the Yukon and the fact that I'm doing the majority of the 278 and 276 hearings as lead counsel for the program is that I hear well before any application about a hearing that's coming. So I could hear from a victim service worker who's been at the fixed date court for the trial, where it's being put on the record that there is likely going to be a 276, 278 application, and they inform me, and right away then it can be connected with the complainant and see if they do want counsel, and speak to them. I've also been told early on by Crown, who's been involved in pre-trials when it's come up, because usually in these cases there will be a judicial pretrial and well before the trial, and it'll be usually addressed at the pretrial that there's going to potentially be an application. So again, I can be connected early on. Obviously doesn't mean I have standing earlier on or that I get the materials earlier on, but I'm usually connected. And what's so great about that is just helping, like if I'm at the pretrial, my dates are canvassed as well as Crown and Defense. So it just helps to move things along really quickly without delay. And a shout out to our trial coordinator as well. Our trial coordinators, they often will, if they'll be sitting at a pretrial and they hear that it's coming up, and they'll right away say, well, we need to bring the complainant's counsel into this potentially. So we'll set another pretrial to make sure these dates work if the complainant is going to exercise their right to counsel. So it's definitely the benefit of a small jurisdiction. The communication lines are well open, and I hear early on. So that's what's happening in the Yukon right now. I don't know how it works otherwise in Ontario, if anyone wants to speak to other jurisdictions.
I mean, Dawn, I think you should probably take the lead here. You've got the best seat in the house for this.
Usually our victim witness assistance program, which, comparable to victim services in other jurisdictions, they will often reach out to find counsel for the complainant. Also, sometimes individual crowns reach out, sometimes legal aid will send out an email trying to find someone who's available. I don't think I've ever seen, I'm not aware of any case when one of these applications have been brought and complainant's counsel has not been contacted. I don't think that I'm not aware of any that have slipped through the cracks in that regard. And I don't think that ever it's the judge who actually advises the complainant of her right to counsel. It's always the support folks who bring it forward.
Yeah. Yes, that's what's interesting about that section. Yeah, absolutely. And I mean, even in the cases where we have a roster of lawyers in the Yukon, and there have been times when other lawyers have appeared on these applications, but again, we hear very early on in the process through the victim service worker or Crown, and we're able to contact somebody on the roster of lawyers and get them connected very early on in the process. So it's very useful. And that leads to the next question: when does the Yukon government fund complainants counsel? Well, again, because the way our model is, we have the lead counsel who does a lot of the hearings. So right whenever I'm connected, I will. The process is funded, I guess. So that can be from giving ILA. Sometimes I may be brought in early on in the process in terms of a waiver to give independent legal advice, and I've already connected with the complainant, and later on that turns into a representation on one of these hearings. And we had a constitutional issue in one of our cases. I didn't have standing, obviously, but I was able to listen in and be a part of that. So yeah, the way our model is set up, the Yukon government funds complainants counsel in all of these hearings if they want it, and it can be from early on in the process. So yeah, I'd like to think that does speed things along and streamlines the process. But again, it's much more possible in a smaller jurisdiction, I would think, than a big jurisdiction like Ontario.
In Ontario, the Ontario government also funds victims counsel for certainly for all the hearings, for the production hearings or any of them under the new legislation. We get an order appointing counsel. And sometimes it'll have the name of the lawyer listed. Sometimes it might not, and it can be filled in later. I think some crowns, knowing that there is going to be a hearing, might even be proactive and just get that order signed by the judge so that they can have it ready to go. But that we also have in Ontario, and you may or may not have this in Yukon, but we also have an independent legal advice program, advice as distinct from representation. This order appointing counsel would cover the representation, but we have 4 hours of free legal advice for complainants, for any complainant of a sexual assault. And that I think could be used for a waiver purposes, even if not for representation in court at a hearing. And that may or may not be the same lawyer who's used. Hopefully it's the same lawyer, but it may not be. But yeah, I think we're trying to get more streamlined about that. And I agree with Dawn. I don't think that there's been any cases that I know of. The ones I know of, usually the judges are even the ones asking, is their complainants counsel on board? And even before that stage 1 hearing, we make sure that there's somebody out there that the complainant wants to use.
Yes, and we do have it. So it's operated out of Victim Services to the independent legal advice, and that's up to 4 hours of free legal advice. What we have is for victims of sexualized violence, but also intimate partner violence as well. And we have a roster of lawyers. So again, yeah, just like I said, sometimes I'm brought in at the advice stage to help with a waiver, but then that later turns into representation, and I'd be the same lawyer involved. But we do have a roster of lawyers that go beyond criminal, that have family law expertise and civil law. So
yeah, same with Ontario.
Yeah. Okay. So
I was gonna say,
okay.
I don't have much to add. I just show up at the hearings and there's counsel answering, and we're getting factums, and it happens behind the scenes.
So what is the scope of the complainant's participatory rights when we're now looking at the stage 2 hearing, the right to make submissions? Do they have a right to call evidence? We heard about factums, written arguments, right to cross-examine the accused. What is the scope, Dawn, of those participatory rights?
The early cases, for example, the Boyle case and a case called AC, which was the first case that looked at the constitutionality of the sections and found that it was upheld. Those cases, early cases, found that the right to attend and make submissions had to have meaning, and seemed to provide a wide scope of participation rights to the complainant. And in AC, and I think that this is a really important point, Justice Sutherland indicated that the right to appear and make submissions and be a participant in that hearing is limited to that hearing. So one of the things that I have to tell every single one of my complainants is that I don't represent them at large. So I'm not going to be at the trial. I have no right to object if I don't like a question that the complainant's asked at trial. My involvement is limited to protecting their privacy interests on basically 3 types of applications: third-party records application, evidence of other sexual activity, or evidence that's in the possession of the defendant. So within those hearings, it appears that we have the right to fully participate. But there are cases that particularly in the right to cross-examine. So some lower courts have found that the complainant does have the right to cross-examine the defendant or the affiant on the affidavit, whoever that is. For example, Boyle, FA, and AC all found that the complainant had the right to cross, whereas other lower courts have found that they do not. For example, BG, citation is 2021 ONSC 2425, also JD, 2021 ONCJ 600. And there's a relatively new case by the name of Morello, M-A-R-E-L-L-O. I don't have a citation for that yet. The copy that I have is an unreported case. It's from the Toronto Court of Justice. the Ontario Court of Justice rather. And those cases found that the complainant does not have the right to cross. So we've got a split in the case law on that issue. Now, this was an interesting issue at the Supreme Court because at least 2 of the judges on the Supreme Court felt very passionate about the fact that the complainant should not have the right to cross-examine. So I don't know if, obviously none of us know what the Supreme Court's going to do, but I think it's possible that they may find that the complainant does not have the right to cross. But that's where we're at now. I have to say that from a practical perspective, it's not something that I necessarily engage with on most of my cases. If the Crown wants to cross-examine, that's usually adequate. So this isn't something that I'm in a big rush to engage in. I don't think it's necessary. And also from a practical perspective, I don't really want to give the defendant the opportunity to improve what is otherwise a not particularly good affidavit. So for both practical reasons and legal reasons, I often don't exercise that right, even when it's quite clear that the judge would allow me to cross.
I would think any cross-examination, even if it is allowed by complainant's counsel, can't be repetitive of anything that the Crown has done. And so I would think practically the Crown would go first. And I've certainly been in cases where I went first and complainant's counsel, whether they were planning on crossing or not, said I don't have any questions. And I don't really know, maybe there's been one, but if that, where complainant's counsel has sought to and been allowed to and actually cross-examined. I actually agree with Dawn that in most cases, they don't feel that it's necessary nor strategically advisable to cross-examine. And I suppose the only question I would have to Dawn is what about things like authenticity? If the question is about authenticity and you are dealing with it at that hearing stage, when it's appropriate, because you don't want to have to deal with it mid-trial, what do you do about that?
That's right. Well, that would be a great example. Also, it's possible that complainant's counsel will be in possession of intimate details that the Crown is just not going to know. So there may well be times when it is appropriate. I've done it. I've cross-examined on affidavits. I'm just saying it's not something that I race out to do in every single case. So yes, the complainant certainly can seek to do so. And I think that's a very good practical way of dealing with the situation, is that the Crown goes first. And then the complainant's counsel can see if there's any loose ends that have to be tied up. But again, it's not always advisable in any event to improve an otherwise lacking affidavit.
Jake, so moving into an area that was also provided some heated exchanges at the Supreme Court of Canada. How much notice is required for a 278.93 application?
I'm actually interested to hear about how that went at the Supreme Court, but I mean, the code specifies that it's 7 days. That is by virtue of 278.93 sub 4. I mean, the practical reality is that these applications are set months in advance. There's also the Ontario rules, the Ontario Court of Justice rules that suggest that there should be 30 days notice on applications. Listen, I've always been of the practice. I file my applications on these 30 days before the hearing date. They could be quite complex areas of the law. They're very difficult, and a 7-day turnaround for the Crown and complainant counsel to come up with a response, I think could cause some issues. I looked a bit into the Yukon rules. It looks like there is nothing about this 30-day for applications. I think it was 7 or even 2 or 7. Obviously the code says 7, so I think it would definitely have to at least be 7, but I'm very curious to hear about how that'll go, because I mean, I see it two ways as well. Like if you file the application 7 days before, the Crown has to come up with a quick turnaround, and so does complainant counsel on their response. But it also means that you're only going to be getting the response right before the hearing as well, which I don't think is super helpful to defense counsel. Like if I file within 30 days and then I have the response maybe 2 weeks later, and which is what's in Ontario at least seems to be suggested, then you still have 2 weeks before the hearing to review the response and see what you have to reply to. So, but the code says 7.
I think that that's a really great practical approach that you have, Jake, because it allows everybody a little bit more time to be adequately prepared. And I know that in Ontario, at least some of the Crowns do try to push at the JPT, for example, to set timelines so that stuff will be filed at least 30 days in advance. So I think that that's a really good way to deal with it.
And I can add, oh, go ahead.
Yeah, no, go ahead.
Oh, I was just going to say that although we don't have specific rules in the Yukon, they're usually brought well in advance. And that's discussed at the judicial pretrial, and Crown, the judges, everybody's aware that they should be brought well in advance to keep things moving, and timelines are set for Crown and complainants counsel to respond, and then for defense to have adequate time for a response to the response as well. So that's the practical reality here, set well before.
And
Go ahead, Jay.
no, I was just going to say, I'm sort of surprised that when the amendments were made, that would not have been something that would have been changed. I don't know if, because I could be wrong. I think that the 7-day notice was there before as well on just the 276 before all these new procedures came out. I mean, it's something that they could have decided to change. I don't know why, but in any event, it's kept the 7 days as this, I guess, status quo for now.
I don't know why either. And the only thing that was changed in the third-party records regime by Bill C-51 was that it extended the notice period to 60 days. Years ago, it was 7 days, then they extended it to 14 days, which was completely inadequate. Now we have 60 days. So yeah, why wouldn't they have given us 30 days on the other applications? But they didn't. They only gave us 7.
I mean, I think it's at least 7, and the rules of court seem to trump even the legislation. Certainly the litigation at the Supreme Court, I don't think focused on whether it should be 7 or 30, it's whether it should be brought before trial or whether it could be brought mid-trial.
Right.
And I think that's sort of the philosophical issue that is really the subject of a lot of the litigation. And in the materials, we have sort of 2 cases in Ontario, one called ARS, where Justice Breen said, no, in order for the legislation to be constitutional, the accused has to be able to bring it mid-trial so that he's not showing his cards before she gets on the stand and testifies. And Justice Chapman, in I'll call it a bit of a rebuttal decision, not exactly, but it seemed to have that, gave all the reasons why Parliament couldn't have anticipated or contemplated these as routine mid-trial applications. I mean, it just would, if you can imagine every single sexual assault trial where these were only coming mid-trial, it would bifurcate every single trial. In the middle of the trial, it's already bad enough we have all of these pre-trial motions beforehand, but if it's in the middle of the trial, you've got a jury waiting, you've got a complainant who's on the stand, who now, number one, might have to make a choice. Do I want to exercise my rights under the section and protect my privacy rights, or at least try to, or do I want to just get on with this and forget what my rights are so that I can proceed with the trial? Because if there's a mid-trial application, the practical reality is there is going to be an adjournment of some sort. You're going to have to now get complainants counsel on board. There's going to have to be litigation. As I said, the judge is going to have to render a decision with some reasons. And that's going to cause the complainant to have to basically go away and then come back at some later point in time. And that's not in the complainant's interest. And quite frankly, it's arguably not even in the accused's interest. It's in the interest of everybody once their mind is focused on the issues to just run the trial. And if you have a jury, I mean, that's an impossible situation. Certainly I would argue Parliament couldn't have contemplated mid-trial applications, especially when these are conducted by juries. Now, I would say that there is a distinction between the type of evidence that the accused reasonably knows that he's going to use before the trial starts. So for example, if there is a record the accused has, whether it's sexual or non-sexual, and it is going to contradict something the complainant said either to the police or maybe to her evidence at a preliminary hearing if there was one, the accused has that. He knows he's going to use it. There's no reason why that shouldn't be brought beforehand. Because the complainant is already tied to whatever her statement was. So if there's a clear contradiction, a clear impeachment there, he's got her one way or the other, whether she knows about it in advance or not. I would contrast that to cases where the complainant says something in her examination in chief or even in cross-examination that was legitimately unanticipated by either party. It wasn't something that was included in her police statement or her preliminary hearing evidence. And it so happens that the defense has evidence that contradicts that. That happened in a case called Harris in Ontario, where the complainant in a case, in the course of her testimony, talked about the fact that her and the accused were in a platonic relationship. And the accused was therefore mid-trial entitled to bring a 276 application to try to adduce evidence to contradict that. But it was something that wasn't necessarily anticipated. So I do draw that distinction, and I don't think obviously the legislation says 7 days in advance, or otherwise if in the interest of justice, and there may be cases where it should be brought mid-trial, but not routinely. And well, yes, the Supreme Court should definitely be opining on that, because that was the main argument in the JJ appeal that went up.
The reality is that a trial is, this organic living creature, and stuff pops up in the course of a trial that we just have to deal with. And I agree with Jill. When that happens, okay, so now we have to deal with whatever the thing is, 276, 278.92, well, that should always be dealt with in advance, I think, or a third-party records application. But as a matter of course, it just does not make any sense for trials to be interrupted for these types of applications. And whenever possible, they should be brought as a pretrial motion.
Jake, do you want to wade into this? And
Yeah, for sure. I think it's difficult to there's some things you just can't foresee happening at a trial, and I think both Don and Jill have spoken on this. There are some things you cannot reasonably anticipate that happen at trial, where the defense will have nothing. There's no other alternative. The defense counsel would have to bring an application. Now, I don't know if this was something that came up at the Supreme Court or not, whether there's sort of hypotheticals, right? Because you could be in a position as a defense counsel where you're bringing an application that's somewhat premature based on the evidence not being heard already. So, when Jill mentions you've got something to contradict the complainant on something she's going to say, well, what happens if the complainant hasn't opined on it one way or another yet? So if something comes up that has not, that where the complainant it's silent in the interview with the police, and then based on a question that's asked by the Crown, it then comes into play, which is something that does happen. The police officers don't always ask every single question that may ultimately be important at the trial, or they may not know is something that will be important at the trial, and then it becomes something that is quite important. And then as a result of a question that's asked by the Crown, well, then all of a sudden this now comes into play. And then does defense counsel really have to bring an application saying, well, if her answer to a question about this is X, then I'd need the application. But if it's not, then, well, it's consistent with the information I have, and therefore I don't need to bring it. I don't know if there's any comments that would be made on that, but I think some things may still come up during the trial, but ultimately when you're looking to, I don't think it's really in anyone's interest to derail a trial. in the middle of a examination of a complainant. So if it can be avoided, it should be.
You know, I think, Jacob, what you just said about whether you can ask the complainant and, you know, depending on what her answer is, you'd either have to bring the application or not. I think it depends what is being asked. I mean, and that kind of goes to the definition of a deuce, which has been sometimes contested, at least in Ontario. You know, I think if we have to go back and think, does defense have a record or a piece of other sexual history, whether communication or not? And if they want to ask the complainant about that, I mean, obviously, if it's anything 276, they have to bring an application, even if they want to ask her about it, right? Not necessarily to adduce a record or a picture or photo, but any kind of evidence that they want to adduce, put in, they have to bring an application. But if we just talk about a private record that's non-sexual, right, that just falls under 278.92, I think if it is a record for which she has a reasonable expectation of privacy, even asking her about it and being stuck, you know, arguably being stuck with the answer is still adducing, because they only know about the contents of that record from the record itself. And if they have that record, either, you know, from because they got it at a production hearing or because they just had it, the spirit of the legislation, I think, is to ensure that the complainant, first of all, has notice that she's going to be asked in open court about such a private record that she would have reasonably expected to remain between her and the recipient. And also that she is able to exert her privacy interest over that record, such that that balancing has to take place. So I don't think the legislation was about the medium, it was about the message. And that's why I think that even if the content is going to be put to her, it should be the subject of an application if it is in fact a private record. And so if that is something that happens mid-trial because the defense legitimately and in good faith didn't anticipate needing to use it, but realizes mid-trial that they will have to, then I would say that that should be the subject of the mid-trial application, and hopefully it can be dealt with as quickly and as streamlined as possible.
Right.
I think it might be worthwhile at this stage, because I'm just looking at the time, because I mean, we have referred to the Supreme Court of Canada, to the Supreme Court of Canada case that's now before the Supreme Court of Canada. And not everyone, I'm sure, is completely familiar with all the issues. And it may be worthwhile at this point, before we go into questions, just to discuss some of the main issues about the constitutionality of the legislation and what was brought up for the Supreme Court of Canada. There were companion cases from BC and Ontario, and it was actually Dawn, you can speak to this, but it was actually the complainant from Ontario who brought the appeal, and then in BC it was JJ. So the case was Reddick, but the complainant, it was AM, I believe.
Yes.
AS.
Sorry,
Sorry,
just AS. Yep.
Yeah, AS. Yeah. So, I mean, maybe we can go through each of you and ask the question. Well, we'll start with the Ontario case. So what were the main issues in terms of that case that were argued before the Supreme Court of Canada? I mean, we heard there were motion for directions. What else? And what's your opinion on it?
Who are you addressing that?
It's a broad question. But.
So in terms of the AS appeal, one of our Superior Court judges in a case called Reddick found that 278.92 and 278.94 sub 2 and 3, which are the sections that allow the complainant to participate and be represented by counsel, he found that those sections were unconstitutional. So as an aside, that led to a flurry of what came to be known as Reddick applications, whereby the defense, and I mean starting the next day after this was released, would race into court with the Reddick decision and say that they were relying on Reddick to exclude the complainant from any of these proceedings. And the courts very quickly said, no, you have to bring a notice of constitutional question. And so they had to do that. The Reddick application sort of fell to the ground. But I am counsel for the complainant in the Reddick matter. And she brought her own appeal to the Supreme Court of Canada. And the Supreme Court of Canada granted us the right to appeal that decision. And we were joined up with JJ, and JJ, which came out of BC, as Sue was saying, the issue on that was that the judge had found on the timing issue that it was okay for the defense to bring a midstream application. That was appealed by the Crown. And JJ was well on its way. I think that they actually had a date to be heard. And when the Reddick appeal came up, we were joined with JJ, and ultimately in October, over 2 days, both of the appeals were argued with many, many interveners. So the hot button issues, I think that are, I mean, they could entirely strike down the legislation. That's entirely possible. I think the real hot button issues are the timing question and the definition of a record in 278 as it applies to 278.92. And as a lesser issue would be the scope of the complainant's right to participation, specifically, as we were saying earlier, the cross-examination issue seemed to be very interesting to the court. So that's sort of a high-level overview of what those appeals were about.
I mean, there's certainly been a lot of cases across the country going both ways, upholding the constitutionality and saying that it's unconstitutional. I know in the Yukon we have a territorial case that said this idea of the defense having to bring the application, advance disclosure, was unconstitutional, and then we have a Supreme Court case of the Yukon that upheld the constitutionality. So even in our small jurisdiction, we have cases that have gone both ways. So it will be interesting to see. Jill, what's your take?
You know, I think Dawn did a really good job of sort of highlighting the issues. I mean, there were so many issues that were litigated in the factums. You know, the right to surprise and whether having complainants counsel means that the accused is against two prosecutors. Does it undermine the role of the Crown? You know, is section 278.92 overbroad? I mean, these were all issues that were litigated in the factums, but I think at the hearing, my sense was that most of the judges were most interested in the definition of records and whether that includes communications between the accused and the complainant, and then specifically, does it include communications about the offense itself? So I think that, you know, we should all kind of watch for that, because hopefully they will opine on that. And quite frankly, depending on how detailed the judgment is, it could really help from a practical level. And you know, Justice Moldover took a pretty strong interest in that issue, and he's a pretty practical judge. I think he knows how to speak to the trial courts. And so hopefully we'll hear something from them that will assist everybody and maybe even eliminate many motions for directions. And I think some of the ancillary issues, like whether the accused has the right to cross-examine, you know, what is the meaning of a deuce? There were some other little questions like that were asked, and it would be certainly helpful if there was commentary by the court on those issues. Whether or not the whole regime is constitutional, I mean, I think a lot of it might depend. I don't know what they'll decide, but certainly the notice issue is, I think, the next big issue. I can't imagine a court saying it's constitutional, but it's okay to bring it mid-trial in every case, because I just don't think that aligns with their jurisprudence in cases like Jordan and Cody. But we don't know what they're going to do. It may be that they decide it's not constitutional, given that the code says it has to be brought in advance, and that violates the accused's fair trial rights. Because that was really the crux of the defense argument, was that they shouldn't have to show their hand beforehand, that the complainant, they should be able to cross-examine the complainant, you know, clean, without her being aware and being told of the nature of their cross-examination beforehand. And when you look at the legislation, and it says that it has to be a an application with detailed particulars articulating the relevance of the issue at trial, the defense argument is that that really gives her this broad perspective of what the defense theory is about. And of course, the contrary argument to that is, doesn't matter. I mean, we've been doing third-party record applications for 2 decades. It was declared to be constitutional. Our other sexual history applications we've been doing for decades, that was constitutional. And in both those types of cases, especially in the third-party records application where she has had standing at both stage 1 and stage 2, it's not a big deal. She sees the application record. She might be there at the hearing. She knows exactly what's being litigated. It doesn't affect her evidence later on, even though she reads what the theory of the defense is. So there were lots of arguments that talked about that. And there were also arguments, I think, about the effect on the complainant when a mid-trial application occurs, and how that is going to affect her perspective of fairness, and how difficult it would be for her to have the proceedings bifurcated, and have her leave and then come back. So yeah, I mean, it was interesting. I think in total there were maybe 24 lawyers that made submissions, all by Zoom, all with slightly different perspectives. I think some overlap, but not completely. And we'll see what happens.
Absolutely. Any comments, Jake?
No, not really. I mean, I wasn't, I didn't watch any of it, but I was wondering if, was anything ever made of, like, the practical reality is, like, as a defense lawyer, if your client tells you that the complainant and him engaged in conversation about something, then that could be cross-examined on, right? And then that could be things that include privacy information if it was just a conversation between the 2 people. But as soon as it's now reduced to writing is when the application has to be brought. Was that ever something that was sort of discussed or canvassed? Because I always thought of that in a practical way as being a little bit backwards. You can cross-examine on anything they spoke about, but you can't cross-examine if ever it's reduced to writing and you know exactly what was said, without, of course, without bringing the application. But as a defense lawyer, I always thought that seemed a little bit counterintuitive, I guess, if you're able to still and I'm not suggesting that defense should be able to cross-examine on a conversation if they have a record about the conversation. That's not what I'm trying to suggest, but just in terms of, you're able to cross-examine about conversations that were had between the 2 parties without any type of application.
It wasn't litigated, I don't believe.
Okay.
But I think what you're talking about is the distinction between oral communications and written communications, or recorded communications. And I mean, I think we all take the risk that you say something orally to someone and they're going to repeat it, or they're going to do something with it and tell someone else. And I guess, that's just the tattletale risk. And I don't think the courts have necessarily protected that tattletale risk, right? But when it comes to records or recordings or things like that, we have robust case law protecting it, like from Duarte.
Right.
But I think also a court puts more stock in a written communication than in an oral communication, right? So if you cross-examine a complainant and say, well, I suggest to you that you said X, Y, Z, she says no, and Q says yes, and the court just has to deal with that. But I think the court logically would put much more stock in a written communication. So there has to be more scrutiny, I would say, over written communication. But also the experience of a witness being all of a sudden in open court handed their own written communication is a much more visceral experience than suggesting to them that they said X, Y, Z. Because again, we all live with the tattletale risk. So I think it's a good question. It's a good issue, and it's something people have probably litigated in the trial courts, but I don't believe that it was litigated specifically at the Supreme Court.
Okay.
Any other comments? I'm going to start looking at the questions here. Getting near the end. I did want to, I do see that someone was asking because they unfortunately got the wrong time. This is being recorded, so people will be able to go back and review the whole proceeding. And I'm also told that the PowerPoint will be available on the Yukon Law Society website as well for anybody who wants to get the PowerPoint that way. Just give me one moment, and we welcome questions now from our audience. This is to do with the conversation on authenticity that was brought up. Why would authenticity not be a trial issue? Isn't that something for the jury to decide who is telling the truth about authenticity? And how would a trial judge decide who to believe on the authenticity issue without viva voce testimony and cross-examination? I think that came up during the motion for directions, if there was concern about authenticity.
I'm not 100% sure that I understand the question, but my concern with the authenticity is that we have a motion for directions, and if the complainant, if she knew about it, would say, no, I never wrote that text message, that then opens up a whole bunch of other stuff. Jill, I'd ask you, do you know of any cases where that's actually been litigated?
I don't.
Yeah,
No,
as I
use
say,
it as a hypothetical.
yeah, I've come across it in my practice on more than one occasion, but it's never percolated up into a reported case. So my concern is that at the motion for directions, without the participation of the complainant, the court can find that an unauthentic text message is admissible when actually it shouldn't be admissible, or it's incomplete. And if we had the complete text exchange, it would completely change the flavor of the conversation. So I'm not quite sure. I'm not quite sure if that answers the question or not.
I guess
Jill or
the
Jake,
other,
do you guys have any thoughts?
well, I guess the other issue is if, let's say, the complainant didn't have standing and the message went in and she was cross-examined on it at trial. I mean, the Crown can't speak to her when she's in cross-examination. And so it would be very difficult for the Crown to even know of or lead at that it's not authentic. That is something that almost would have to be determined in advance, and that would be at the hearing. And so she has the ability.
Thanks for saying that, Jill, because I sort of made the leap that that would be the issue. So the example that I had about the incomplete text, the one that the defense is looking to establish as a recantation, but actually, in my view, is a prior consistent statement. If that, and that's a very young complainant, but for any complainant, in the heat of the moment in cross-examination, to be confronted with that incomplete message, almost for sure, she's not going to be able to say, oh no, 2 years ago, I sent another text message that said X, Y, and Z. So that's right. It's very unfair to the complainant, and it's not likely that the court will be able to get the truth of that matter when these unauthentic or incomplete messages are put before the complainant.
And we usually don't care if she said, let's meet, if the message says, let's meet on Friday, and maybe in fact it said on Saturday. I mean, obviously there could be that issue if it's not declared a message, but certainly when there's intimate private messages, that can be litigated beforehand.
There's a question directed to Jill and Dawn. In general, Crown and RCMP will discuss the importance of text communications with a complainant and ask the complainant to provide those if they have any. What are your thoughts about the complainant not providing communications in their possession to the Crown or RCMP when they are available to them, and or saying that there were not any communications? In such case, do you think that the complainant participation and hearing evidence at stage 2 is problematic? That's a long question.
I hope I understand the question. I think that certainly there's nothing wrong with the police say, or the Crown saying to the complainant, did you have contact with the accused after the fact? There's nothing wrong with that. There's nothing that suggests that just because the complainant did communicate with the accused after the offense that she's otherwise not telling the truth. That's obviously a disregarded myth. But I think that it depends. I mean, I don't know that the RCMP or the Crown are going to say to a complainant, please hand over every communication that you've ever had with the accused. We don't do that. We don't do data dumps of the complainant's phone because we accept that there is privacy in those communications. Sometimes a complainant will on their own hand over communications, and usually those would be ones that I guess she feels or objectively are inculpatory. And again, as I said earlier, if she's handing over communications between her and the accused, certainly in Ontario, Crowns may take the position that for disclosure purposes, we are going to provide those, and that the reasonable expectation of privacy is different vis-a-vis disclosure of a message that the accused has already seen versus the ability to reduce that. We would hand it over saying, but you have to bring an application. So I think it depends on the case, but sometimes there will be messages that are provided to the Crown. Sometimes there won't be. And again, if the defense, and I will tell you, often complainants, if they have been, they say they've been assaulted by the accused, if there is long text messages or WhatsApp communications, complainants often might delete them. So they won't have them, and they won't even remember what they have said years ago. And that's the situation sometimes where the accused has the message and wants to use it, and that becomes subject of the legislation.
She also may not want to participate with the prosecution. I mean, certainly in the context of human trafficking, often the complainant, but she doesn't want the charges to proceed. So she may decline to provide what otherwise would be maybe helpful information to the Crown. So I think there's lots of reasons why a complainant could decide to not provide that kind of evidence. I'm not sure that it may or may not affect their credibility.
It sounds like there's also two different whether they don't want to hand them over versus saying that there were no communications when in fact there were, that becomes more of a credibility issue, I think, and definitely makes it more important. But I think the question though then asks about whether participation in the hearing at stage 2 makes it problematic. I don't know if the question is supposed to be meant as, does it impact their ability to participate in stage 2? I wouldn't see why it would or why it wouldn't change anything. I think they would still have the right, obviously, to participate. Whether that then becomes part of the judge's consideration and whether there's expectation of privacy, I don't really see anything.
There was a case called McKnight from the Queen's Bench in Alberta early on after the legislation passed. And I seem to remember that the judge there said, even if a complainant has provided by way of disclosure communications between her and the accused, that doesn't eliminate her privacy rights altogether. So I don't know if the question is, if she's provided these messages, does that somehow eliminate her ability to get involved in the hearing? And I don't think it does, because I think it's two different things. She may provide them, they may be disclosed, but that doesn't necessarily, that's not dispositive of whether or not they should be adduced. That's going to be a judge's decision. And again, that's going to be factors. That's going to be the balancing that has to take place.
That's brought up in some of the waiver decisions as well, that just because they're provided to the RCMP doesn't mean that that's a full and informed waiver of their reasonable expectation of privacy.
Well, that's right, because they have to know their rights. And,
yeah.
And when a complainant is providing text messages to the police or even to the Crown, they don't necessarily know that they have these rights under the legislation. And so that's where complainants counsel becomes really important in terms of letting them know what their rights are.
There's another question here, and actually, I think it was one of the questions, it leads to one of the questions we didn't get to. Does sexual contact or communication shortly before the alleged offense fall under 276? Because someone's asked, the accused, of course, can argue that the offense is not other or sexual activity. So
that is a really good question, and one that I don't think there is a straightforward answer. I think it depends, you know, how long is too long? Is it 5 minutes before, half an hour before? I mean, we know that a complainant can't consent in advance. There isn't implied consent, et cetera, et cetera. We know all that. And I think judges keep that in mind. But, you know, where do you draw the line? It's really difficult if there's a precursor to the event in question, whether there's kissing or fondling or flirting leading up to the event in question. Does that then get excised and that then becomes part of a 276 application versus that being part of the offense in question? I think it's really case specific, and there's some judges that have said err on the side of caution and assume that you do have to bring the application, and relevance can be argued then, because we do want to make sure that that evidence isn't going in for an improper purpose, which is to suggest that because she consented half an hour before to one act, that means that she's consenting afterwards. So often it's going to be, I would say, an exercise of defense articulating exactly why they want this evidence admitted.
I've seen cases where the judge phrases it as whether or not it was part of the same transaction. In one case that I had, the defendant came over to the complainant's home at, say, 6 o'clock. They had consensual sex in the living room. A little while later, they had consensual sex in another part of the house, and then eventually make their way up to the bedroom where she says, no, you were too rough with me last time. I don't want to have sex with you again. She alleges that he then raped her. So from my client's perspective, those were 3 discrete events. The judge, however, found that they were part of one transaction and that the defense did not have to bring a 276 application. So, you know, I don't know. Jill's right. It depends on the individual facts of the case.
And I want to add one other thing, and this is something we haven't talked about yet, but the 276 regime applies to the defense. They have to bring a formal application if they want to adduce evidence of other sexual activity. But what if the Crown wants to adduce that evidence? It used to be, before the trilogy from the Supreme Court, Barton, Goldfinch, and RV, that you know, the Crown would just sort of lead that evidence and sometimes realize, oh, I guess that sort of felt like, smelt like, sounded like sexual activity, and everybody would fumble. Now the Supreme Court has been very clear that the Crown is not subject to the statutory application under 276, but if the Crown wants to lead any sort of other sexual activity or communications or innuendos or anything like that, we have to, at least at common law, bring what we'll call it's not even an application, but under C-Boyer, we have to vet it with the judge. And we don't bring a formal application necessarily, but it would be something that we tell Crowns, raise it at the judicial pretrial. Let the judge and the defense know that you're going to be leading evidence. For instance, let's say there was something that consensual sexual activity that happened 60 minutes before, and then 30 minutes before, and then the offense in question. It may be that in order for the complainant to provide her evidence about why she knows she did not consent to, let's just pretend anal sex was the allegation, she may have to say, because when we were having consensual vaginal sex beforehand, I specifically said to him, I don't want to engage in anal sex. And it would be hard for her to give that evidence without talking about those earlier sexual acts. And so the Crown may want to lead that as part of its case, and it would be incumbent on the Crown to let the judge know, we are leading A, B, and C. This is why it's relevant to trial. It's not being adduced for any improper purpose. And the defense, I would say, can cross-examine within the four corners of that evidence that the Crown has led. If they want to go beyond that, of course, they would have to bring an application. And we in Ontario are trying to do that now at judicial pretrials so that everybody is crystal clear what evidence is going to be led and by whom and to what extent. And so I think that's an important thing to say too. The Crown can't just, it's not a free for all for the Crown. They're not subject to the same strict applications, but they do have to let the court know that they will be leading certain pieces of evidence. And obviously the complainant will know about it. It's not going to come as a surprise to her because the Crown will let her know what questions she's going to be asked.
So in those cases, has complainants counsel made submissions, or has there been any, or just they usually know about it ahead of time? So, and there's not usually an issue from complainants counsel standpoint.
I have been invited by the Crown to participate in a Crown CBOIR application. And I've been involved in cases where there was a 276 and the Crown was also bringing a CBOIR application. So I was invited by the court to make submissions on both. And we sort of dealt with it all in one big package. But the complainant is not entitled to have counsel on a Crown CBOIR application. So if it happens, it's an unusual situation.
That also happened here where I was invited to make no one had any issue with me making brief submissions, but there was no issue on it, and it took place at the same time as the defense application.
I do see a question here. It's for me, so I'll read it. It is, how are Ontario Crowns handling disclosure of sexual assault examination kits? Is there a presumed waiver because it's part of the investigation allegation? Well, it's not a waiver in the sense that Dawn would speak to the complainant and get a waiver. We actually had one case in Ottawa where this was litigated. I don't think it's reported, but I do have the case. It's by Justice Duty, who was also the judge in the Boyle case. And he determined, with heavy litigation on both sides and good arguments on both sides, that the sexual assault examination kit is part of the investigation, and therefore it falls outside of the definition of record under section 278.1, because those are all records, but it's not a record if it's part of the investigation or prosecution in question. And they found that the sexual assault evidence kit, which is the examination that's done at the hospital, is done for forensic purposes. Certainly those pages where it's the forensic form, and therefore we disclose those as first party disclosure. We don't have to get a waiver from the complainant. Our law now says that those are exempt from the definition of section 278.
Which then in turn would mean that the defense wouldn't need to bring the application then to use it.
No, exactly. No, exactly. We disclose it, defense can cross-examine on it. Yeah.
I'll just, one wrinkle to that is I've seen when other sexual activity is referred to in those,
Yes.
on those forms. And if the Crown wants to cross-examine on the other sexual activity, they would still have to bring an application for permission to do that.
If the defense wants to cross-examine, yes, exactly. Some Crowns may redact that reference to other sexual activity. Some don't, but, and actually the forms in Ontario have now been changed so that the nurses aren't asking unnecessary questions. You know, if it's an allegation of breast touching, you don't have to ask if you've had anal sex in the last 7 days. So for, at least the forms aren't seeking out gratuitous information, but yes, if there's reference to other sexual activity, that would have to be the subject of a 276 application.
And I think it would also probably depend on other sexual assault examination kits in different provinces, whether, I don't know if it's been litigated in other provinces as well. I know part of the finding on the sexual assault evidence kit in Ontario was just the basis on how they're taken and how the police are heavily involved in it. So, you know, I don't know in other provinces if that's been litigated and whether the police are as involved in the investigative portion of the sexual assault kit and whether there's been other decisions, but
I don't know, although I will say, I mean, the police don't have to be involved. A complainant can go to the hospital and get a sex assault kit before they've ever gone to the police. They can go to the hospital, get a sex assault kit, which is frozen and saved for when they may go to the police 6 months down the road. But the court has still found that the kit itself is done for forensic purposes, and
Right.
therefore it is part of the investigation and prosecution and falls outside of 278.1.
Right.
Well, I see that it's noon and we've been we've been going without a break, and it's the end of the session. But I really, on behalf of the large group of participants listening today, I really want to thank the three of you for taking time out of your busy schedules to share your extensive knowledge in this area. It's a very complex and interesting area of law, and we really appreciate you speaking with us today. And I know we'll all be looking forward to reading the Supreme Court of Canada decision when it comes down. So we'll invite you back for another session down the road when we get that decision. So thank you very much.
Thank you, Sue.
Thanks for having us.